A new tenant bill of rights was recently released and things have gotten very interesting. In this part 1 video, we're going to discuss 3 items that caught our attention.
Okay, so first one we're going to talk about. If a landlord receives a letter from the government or from the condo association that the building your tenant resides in is unsafe, they have to let the tenant know within 14 days. Now, at first I thought this is way too much time, like 14 days, so many things can happen. But there's another paragraph that discusses if there's immediate danger and they receive a letter to vacate the building, the landlord actually has to act within 8 hours to get the tenant out of there and provide them housing, including paying for it and relocation services for up to 3 months or up until the time that the building is safe again.
That's pretty intense when you think about it, to have to relocate a tenant and pay for all these expenses, but it really puts the pressure on owners to be involved and to be aware. So we can't use the excuse anymore of I didn't know. Super important for an owner to get ahead of that, to be very involved with the board meetings, to find out what's being discussed, because if there's any major maintenance issues that are being neglected, this is going to be the place where they're going to talk about it. The third item is that you cannot ask a new tenant or a current tenant that's going to renew their lease about their eviction history until that individual has been approved to live in this property.
So this one is interesting because it doesn't allow a landlord to ask a tenant if they've been evicted from the get and just outright reject them. It allows a fair opportunity for the tenant to go through the screening process, and later on, if they're qualified, once a credit check is done, then the landlord can see how's their credit and if they've been evicted.
Stay tuned for part 2.